At the end of the day, you want our clients to take our advice, whether or not to take a settlement offer, or whether to proceed to trial. You have to have a level of trust and confidence for them to take that advice, and you don't get that, in one phone call. You have to build that up, and if they're mad at you or they think you're not doing a good job, then you don't have that. And then that's when they're always, talking to the cousin, talking to the brother-in-law that thinks that their case is worth so much more, or gets scared, doesn't think you're going to do a good job, and settles for not enough money because they don't think you're going to be able to handle it at trial. Both those are things we want to avoid. And so I think that's going to be really important. The other thing is, ratings. Google ratings are more important, even on a referral. I went to go meet with a mutual client of ours, actually, down in, not mutual client. It's a case you and I are working on together. I went and drove down to the Rio Grande Valley. I was in the client's living room to do the initial meeting. And, the referring lawyer had told the client about us before, but they actually went and they Googled us and they looked at our ratings and they looked at our, reviews and read all that stuff before deciding whether to say yes or no to us coming on the case. And so to the extent you can get clients that are happy enough to say good things about you and avoid getting clients that are unhappy enough to go say bad things about you online, it really makes a difference. And then finally, you always hope that you have clients either come back if they need a lawyer again, or refer other people they know that need a lawyer again, and keep them happy is a good way to do that.
I think the other brutal reality, Michael, is that, like it or not, lawyers have a fairly low reputation among the public. And so our clients are coming to us with that kind of in the back of their mind. Are we those shady lawyers that they have heard about or read about in the paper? And so it's really critical to building that trust, to be upfront with them and honest with them, keeping them happy, be as transparent as possible. Because I think, like it or not, always in the back of their minds, they're wondering, just how honest and truthful are we being, and trustworthy are we? What I've found is the client is already initially unhappy when they don't know how you're getting paid, how we as the lawyer are getting paid. And if there's any doubt or confusion in their mind about what their lawyer is going to be getting out of their total recovery, I think that's always starting out on the wrong foot. So I like to have very frank, honest, transparent conversations, just matter-of-factly, about the contingency fee arrangement, how it is that the firm will get paid, and how lucky they are to be in a country where they can hire a lawyer through a contingency fee that ensures that when the more money they get, the more money the lawyer gets. So there's a built-in incentive for the lawyer to work as hard as possible on their case. And, always being real clear and upfront that the attorney's case expenses are separate from the fee. And the more I've found, the more that I repeat that and make it a nonchalant kind of conversation, it builds a lot of trust, and they're less uneasy about what's happening in their case when they know that up front.
I used to cut my fees all the time without the client even asking me to cut my fees. I think looking back now, sometimes the client being like, where did this come from? And it wasn't even needed, because when we stopped doing it so much, I'm not saying we never cut our fees, but when we stopped doing it so much, the clients were no less happy. It was all in my head, my own guilt about making money, my lack of truly internalizing belief in my value, in the value of what I provide. So I think until we fix our own heads, it's hard to have those conversations.
I have to really applaud you in creating a formal written policy and a practice of contacting the client, affirmatively reaching out to the client every 30 days and documenting that communication. And not only documenting just a generic communication with the client, but making sure that you have a template of at least 3 or 4 questions that you ask every single time that you talk to the client, one of which involves updating the client on the status of their case. So I think that when clients don't know what's going on in their case and they're hearing radio silence about something as personal and intimate as their own bodily injury, claim, it does create some anxiety and some anger and agitation on the part of the client. So affirmatively calling the client every 30 days really alleviates a lot of that. Some people will say, well, what if I'm not doing anything on my client's case every 30 days? I mean, what if nothing's happening on their case every 30 days or between 30-day periods? The reality is there's always something going on a client's case. We're either ordering medical records. It may not be taking a depot in that client's case every month, but we're ordering medical records. We're scheduling for things to take place in the future. We're hiring experts. We're investigating, the crash. I mean, there's lots of stuff that goes on that may not seem like we're working on the case, but we're always doing something on the case. And so keeping the client apprised of the fact that we're ordering your medical records or we're having a problem ordering these MRI films from this facility, it helps the client know that they're a priority to you, and that's going to make them happy. What I do think is important is setting parameters for what we can do and what we can't do. And so I always tell my clients up front, I feel like Robin Williams as the genie in Aladdin. I can't bring somebody back from the dead. I can't, make somebody fall in love with you. Like I can't make the jury fall in love with you. I can't make somebody come back from the dead. But what can I do? And part of that conversation is letting the clients know I'm not going to be able to bring your health back. I cannot fix your pain. I can learn your story. I can tell your story if you will let me, but setting these parameters about what I will not be able to do has always been kind of a clearing the air of expectations, unreasonable expectations.
But when you survive it, it's a very liberating thing because you just realize, okay, the worst happened. This is a case that I spent way too much money on. It hurts to lose it, but I survived. I made it back. I'm okay. I'm still doing well. And I think there's just something to going through that lets you lose your fear of losing.
It's liberating for them to not worry about whether their lawyer is trying to convince them to do something that they don't want to do.
Exactly.
They're much happier when you put it on the table and say, here's the pros, here's the cons, here's the financial risks, here are the financial pros and cons. This is how much it's going to cost me to actually get through a trial in your case versus how much I've invested in your case right now. And then leave it for the client to decide. And that's also been super liberating for me because at that point, it's the client's decision. I don't have to lose sleep over whether or not, to take the offer on the table at mediation or whether this is a good offer. It's the client's decision ultimately.